Good morning, everyone. My name is Hannah Smith, and I'm senior counsel at Becket, which is a nonprofit religious liberty law firm. We filed a friend of the court brief in support of the Trinity Lutheran Church preschool in the Trinity Lutheran against Comer case, and I was inside the courtroom this morning during oral argument. It's a sad day in America when state governments choose to protect some children but not other children solely based on where they attend preschool. But that's exactly what has happened in this case. The state of Missouri decided that it wanted to protect school children from hard falls and from scraped knees by helping all nonprofit organizations refurbish their playgrounds. The program would replace hard gravel playground surfaces with softer, recycled, shredded tire surfaces. And Trinity Lutheran met all of the secular neutral criteria, and in fact, its application was ranked 5th out of 44 applicants that applied to get a grant that year. So Trinity Lutheran should have received the new playground surface, and all of the kids at its school and all of the kids in the neighborhood who play on the playground after school hours and on the weekends, they would have received this benefit, this public safety benefit that Missouri has set up. But Missouri said no. Sorry, you don't get the grant, and the reason you don't get the grant is because you're a church. Now, according to the state, letting the church get shredded tires was problematic because of an old state constitutional provision called a Blaine Amendment that was originally created to prevent funding from going to Catholic schools, but now those Blaine Amendments are used to discriminate against all sorts of religious groups. Well, in our friend of the court brief, we said the state is wrong, that there's a long line of Supreme Court cases that say that you can't discriminate against religious people because they're religious. And there are a lot of current justices on the Supreme Court who find the history of these state Blaine Amendments highly problematic, that they're based on ugly anti-Catholic bigotry. So in our view, a skinned knee is a skinned knee, whether it happens at a Lutheran preschool or at a Montessori preschool. And the government can't deny these public safety benefits to kids at a Lutheran preschool simply because they're at a church school. Or else it can expect a hard landing at the Supreme Court. And I think you saw that hard landing today. I think a majority of the justices were clearly sympathetic to Trinity Lutheran's position. So Becket urges the court to protect religious organizations from this blatant state discrimination against church schools. That's good for children, and it's good constitutional law. Thank you very much.